I'll come get it and pass it around personally.
Oh.
Okay.
Sounds good. Whoop. If you all can make your way to your seats, we're going to get started. Howdy do. Well, welcome to the July 11th, 2023 meeting for the North County Estate Planning Council. We're happy to have you all here. We're thrilled and honored to have an excellent presentation by Carol Battaglia, AJ Battaglia, and Bronson DeKoning, special needs trust experts. Carol is a national guru, so more of an introduction shortly, but certainly thrilled that you're here. And I think as many of you know, amongst the group here, we're sick of Zooming and we're glad to be here to see people in person. Just a few announcements as we get started. Our August 1 meeting, which is going to be back on the first Tuesday of the month. We're happy to have George Alexander of Shalley, Archambault, and Alexander, one of the council's advanced life insurance professionals, highlighting the opportunities and solutions that life insurance can provide for a client's needs. George is a fascinating fellow with many, many different stories that I've heard over the years, and we've pulled this together into a presentation. Many of you are still in the mode of life insurance. Man, I don't want to hear about that, but the solutions are really amazing as far as what can be done. And we certainly have a number of great life insurance professionals. Besides the August meeting, September 5th, the first, again, back to always first Tuesday of the month, we have Phil Lindsley of San Diego Elder Law. He'll be presenting on the myriad of issues faced by seniors. Again, a national guru, and we're thrilled to have Phil. October 3rd, we've got Dana Telford of the Family Business Consulting Group. He's going to be presenting on family business succession or transition planning. November 7th, we've got RJ Kelly presenting on charitable income tax planning when you've hit a home run, sale of real estate, sale of business assets, or sale of business stock. Then in December 5th, we've got Robert Valera of Voight Real Estate and William Exeter of Exeter 1031 Exchange Services. They're going to be diving deep into the opportunities with like-kind exchanges of real estate. And Bill Exeter's been there from the beginning, even before 1031 came about, when the Starker case first came down many years ago. Certainly a recognition to RJ, a Wealth Legacy Group. A few months ago, I was at an MDRT study group that he runs, and he suggested having a spotlight on nonprofits. And this month, we've got Sonny Pyon of San Diego Rescue Mission. And if she's ready to roll.
Good morning. Yeah, I do, okay. All right, thank you. Okay. So while he gets that up and running, it's a very short presentation. I just wanted to thank you for the opportunity to just present a little bit about the rescue mission and what we do here in San Diego and the greater county. We've been around since 1955, started out as a soup kitchen near Petco Park, and has grown into a full-fledged, homeless services program, trying to get people off the streets initially, and then also more long-term permanently. We're also in the stages of expanding our programs and services countywide. So soon we'll be launching a 50-bed emergency shelter up in Oceanside very shortly later this summer, and a larger facility of 160-bed down in National City, and eventually in East County as well. Yeah, unfortunately, homelessness is a growing need, and it's becoming a visible problem for everyone in our community. And so we're, doing our best to, maximize our resources and, capitalize on our strengths to get people off the streets long term. So some of our core programs and services that we have in our main location in downtown San Diego on Elm Street is MVH, which is a Nueva Vida Haven. It's an emergency shelter for women and children. It's a 30-day short-term stay. And we, accompany kids that are, infants, toddlers, and also grade level students and people that are kids that are in schools. We help them get connected with the local school system. And we provide supports to families and their parents, and including parenting classes as well. Mission Academy is our signature program, which is a long-term 12-month rehabilitation program, clean and sober living that focuses on 3 major areas: health and wellness, education and training, and employment and housing. So we have a housing specialist dedicated to helping people find affordable housing and other resources that they might be entitled to. Education and training, we have an educational navigator that helps people get back on, back to school to finish their GED, go on to get their bachelor's or associate's degree, or get certification for certain skills that, can upgrade their skills so that they can find a livable wage paying job. Children's Resource Center, we have a dedicated staff that works with parents and families to help kids experiencing homelessness succeed and to excel in their school system. We serve as advocates and coaches for parents that are just really trying to navigate, whether it's educational, social, or behavioral issues, or, just making sure that they are caught up with their counterparts. And last but not least, we also help with the Partners for Hunger Relief. Last year, we covered over 2 million pounds of food in partnership with Feeding San Diego and the San Diego Food Bank. And we, after we recover food from, convention centers, hotels, Amazon is actually a big corporate partner of ours, as they own Whole Foods and Amazon Fresh and other local supermarkets and Costco. We redistribute through our warehouse down in National City most of the food to our local partners, 40 to 50 local nonprofits and churches that operate their own smaller food pantries in their region. We also do an active and aggressive homeless outreach. So instead of waiting for people to come to our programs and services, we go out with vans, and we have a shower trailer ministry. We have 2 4-stall shower trailers. One's been active for over a year up in North County in Carlsbad, Oceanside. And we just purchased a second one for South County down in National City, where our new facility will be. And we partner with the local homeless outreach team and other service providers, and sometimes even local churches, so that they can house and host our shower trailers and provide us with the necessary manpower, the volunteers. We also have hygiene kit that we call an ICU kit, which I brought about 50 of them. So if you want to grab one on the way out, so that way, when you see a homeless neighbor on the street, instead of, giving money, or if you don't feel comfortable doing that, you can make eye contact, say, "I see you." That's what it means. And to, give them resources with, soap, fresh pair of socks, toothpaste, toothbrush. And we also have a business card with our information for the emergency shelter and the 12-month program as well. I want to show you a quick 2-minute video about our upcoming Every Heart campaign, which is our capital campaign that we're launching, and we'll be going public with it soon. It's a $25 million campaign to raise funds to rehabilitate our main location on 120 Elm Street, where we house over 300 residents. And because the building was used to be a hospital and we moved back in 2004, we need to upgrade the facility, as well as opening and operation of Oceanside and National City and eventually East County locations as well.
I know you probably feel frustrated and hopeless. And you're wondering, what can we do?
We actually can change the state of homelessness in San Diego. We can stand up and say, this crisis is not going to defeat us.
We can't let despair win, and we won't. Join the San Diego Rescue Mission. Let's give help that works. Help that works means getting more people off the streets today. That's why we're adding 3 new navigation centers across San Diego County. That's 260 new shelter beds available each night. That's 30 days of meals, shelter, and care while we help people recover and rehabilitate. Help that works means changing more lives through our 12-month Mission Academy program. That's why we're renovating our outdated facility to create an environment of healing. That's 79 sleeping rooms and 10 community spaces. Our program helps people address the root causes of their homelessness and their despair. They change mind, body, and soul. They leave behind destructive patterns and they build new and healthy ones. The result, they find jobs and get off the streets permanently. That's our difference. We're not looking for a quick fix. We're committed to long-term, whole person rehabilitation. And we depend upon you for support, not the government. You can help change the state of homelessness in San Diego. Help us double the number of beds available to our homeless neighbors. The way we respond right now will shape the future of San Diego County, this beautiful place we call home. Do not let despair win. Together, let's give help that works.
So as I wrap up, I just want to quickly talk about, our approach. So like I mentioned, last year, over 20,000 people were experiencing homelessness in San Diego County. Then, like I said, through aggressive homeless outreach, through shower trailer ministry, the ICU kids, and just, intentional outreach through our outreach staff with vans going out there, providing water, food, coffee, and engaging people, building their trust and getting them to open up and share, their stories, figuring out their next steps and helping them, figure out where they're going to go next. Our 30-day short-term stays called the navigation centers, and the current one we have, which is NVH. It's going to be for women, men, women, and children and families experiencing homelessness. And then a longer-term 12-month program, Mission Academy. That's a holistic rehabilitation program, clean and sober living. That's in it for the long haul. And once they graduate from our program, they become part of our alumni ambassadors program. So what that means is, as you graduate your universities and colleges and you become an alumni of the rescue mission. And we stay in touch with you, especially if you live in the area. We invite you back for different events, such as future graduations. That way you get to share your stories with current graduates, our donors and supporters and community partners, and just really, share your experience of what your life was like before, during, and after the mission, and, how you can help others, encourage others to get off the streets as well. So again, we thank you for this time and the opportunity to share a little bit about what we do. And if you have any questions, I'll be around after the meeting. So please come see me. Thank you.
Thank you so much, Sonny, and the San Diego Rescue Mission. What a great story, and a lot of ways for us to help in that group. Pete, you want to say a few things about the trifectas?
Thank you, Bill. Good morning, everybody. Good morning, everybody. Great group. I think this is one of our biggest turnouts since the lockdown. Yesterday, I was having lunch with a gentleman here in the room, and the first thing he said when we sat down is, "Thank you for doing the trifecta. I just had a trifecta with someone a couple of weeks ago, and it was just a really good meeting." And then I got here today, and I heard 2 gentlemen talk about, "Hey, how's your garden going?" Like, how do you 2 know that our trifecta? So the trifecta is designed that, yes, we're going to do commerce, but let's get to know each other on a more personal basis. So I'm going to start passing this fishbowl around. If you want to do the trifecta, drop your card in there. I'll do my best to pair you up with somebody that is complimenting in your industry. If you want to have someone in particular, just write their name or their industry on there. And if anybody have any questions, just give me a call. Thanks, Bill. So I'm going to start it here, and Keon, can you make sure it goes there, and then Paul Hines all the way back, and I'll collect it over here.
Pete, thanks so very much. Our master networker in charge there. I want to bring up our meeting sponsor today, Valerie Medina with Trust Properties USA. Great organization and is a nice fit for all of us.
Good morning, everyone. I'm Valerie Medina. I am a real estate broker associate with Trust Properties USA. We have sold and helped over 800 probate and trust estates to sell. And our strategy is called the family flip. So there's 3 simple steps to it. There's absolutely zero upfront cost to the estate. We will flip the family home, and then the estate gets to keep all the profits they worked a lifetime for. The people that we help, they're professionals, including estate planning attorneys, CPAs, professional fiduciaries, financial planners, assisted living and elder care professionals, and also clients, anyone who inherits a property that can benefit from our services at no upfront cost. Some of the services that are more common are that we will cure are a full renovation. We will put in new kitchens, bathrooms, flooring, anything the estate needs to look beautiful. We do evictions and lockouts. We do make sure the home is insured, foreclosure avoidance. We de-hoard and do estate sales and anything personal property sale or disposal. And then we do secure the property. The way we recover our costs is with our fees, we don't charge any interest points or fees. The only fee we earn in the standard real estate commission is the broker split. And then we are reimbursed. We get paid back at the close of escrow. All we charge is the regular realtor fee. I brought a few case studies, just a couple case studies today. And this will give you an idea of what our profile client is. When we get the call, it's usually a severe hoarding case. This particular case that's on the screen, hopefully. What happens is people are living in the house, the homeowner dies, the people living there are typically the beneficiaries, and then the house becomes a disaster. There's hoarding, and in this case, there was rat infestation, very smelly. There were city violations. You can see all the trash in the front yard. Just terrible. It's hard to even walk into the house. So the before value of that house, believe it or not, was $700,000 last year. We came on the scene and we just made it move-in ready. We know what buyers want. So we install all the stainless steel and the white cabinets and flooring, paint. So we were able to sell the property for $940,000, which was a huge increase. And the cost to renovate this one was over $110,000. All that money is fronted at zero cost. And the gross proceeds to the estate was $829,000. And so, we helped them add gain of over $100,000. The client did give us a review, and we really focus a lot on getting those 5-star reviews because people Google us all the time. And in this case, the client, she didn't know what to do. The beneficiary sister wouldn't leave the house. There was a reverse mortgage. And she's facing foreclosure. So it's a very desperate situation. And we can come on the scene and help out with all of that. The second case study I brought, this was a trust. And it had a little bit of hoarding, but it had weird walls and plumbing. And sometimes homeowners do funky things to the houses without contractors. So that's also our profile client. And so we came in and just cleaned it all up. We put the plumbing where it was supposed to go. We cleaned it all up, made it beautiful and move-in ready. Same thing. What do buyers want? They want stainless steel, white, light, pretty, clean. This case study, the fiduciary was very concerned because there was a reverse mortgage and the money was depleted from the decedent's account. And so there was absolutely no money in the estate at all. So we came on the scene and again created equity so that the trust could walk away with enough money to, pay the bills and get the family dog taken care of and all the things that they needed. So it's a very happy ending at the end. And when the administrators and the successor trustees just feel like there's no hope, that's when you can think of me and we can come on the scene and assess the estate and make a way. Our offices, we have grown tremendously in this is my 4th year with Trust Properties USA, and we've grown tremendously. We're in several counties throughout California, and we even have 2 offices in Florida now. So if you have properties in other counties, call me and we can see if we can help you there. Lastly, we do offer free grant deeds, desktop evaluations to our probate and trust professionals if you need any of those services. And again, thank you so much for having me, Bill. And my brochures are on the table. And if you have any questions, I'll be available after the meeting. Thank you.
Valerie, thank you so much. I know the many folks that you've helped over the years. Without any further ado, I want to certainly introduce you to Carol Battaglia, AJ Battaglia, and Bronson DeKoning of Battaglia and DeKoning, the experts in special needs trust. And without getting too far into it, their presentation is special needs trust, everything you need to know. And anything you don't need to know or anything beyond that, call them. They're the experts. But just one heads up, there's this bowl that's going to be out on the table here. They have a study group for those that are interested in learning more, dealing with cases and such as that. So put your card in there if that's of interest to you. Without any further ado, Carol Battaglia.
Thank you. Let me introduce my partner because he's going to kick off our presentation.
All right.
You need this? Can you hear it?
For the Zoom. Got it. Okay, wonderful. All right, good morning, everyone. Carol, AJ, and I were very happy to be here speaking to you about Special Needs Trust. The title of our presentation, Everything You Need to Know, is a bit ambitious, but we at least hope to provide you with a fundamental understanding of what special needs planning entails and provide you with perhaps some practical considerations that may assist you in your own practice. We're going to be, instead of going up to the podium, we're just going to be speaking from here. We're going to be following along with the slides. So if you move to the second slide, the roadmap slide, we're going to start with an overview of public benefits before we dive into first party and third party special needs trust. We'll talk about ABLE Act accounts and why they can be a great tool used in conjunction with special needs trusts. We'll then cover what pooled special needs trusts are and when they are needed. And then we'll wrap up with a discussion about fiduciary duties when administering special needs trusts. And if we have time, we also have some case examples at the end. But if we don't get to them, they're in your handouts for your own reference. All right, so if we go to the next slide, this title slide. So attorneys, trustees, other professionals were frequently presented with a client that has a disability, or perhaps a client that has a child with a disability who rely upon important benefits to meet their care needs. But issues in public benefits arise in all phases of planning, drafting, and administering special needs trusts. So it really is necessary to have a solid understanding of the various rules and regulations. In this presentation, though, we'll only be able to cover a brief overview of the main programs, but it will at least provide helpful context and a foundation for the topics that follow. So if we go to the next slide, we'll jump into public benefits. So there are essentially 2 categories of public benefits: entitlement benefits and needs-based benefits. So with entitlement benefits, there are no resource limitations. So you could essentially win the lottery and you wouldn't lose your benefits under these programs. And if an individual receives only entitlement benefits such as Social Security disability insurance and Medicare, a special needs trust may not be needed, but still might be recommended. With needs-based benefits, or sometimes referred to as means-tested benefits, there are income and resource limitations for eligibility, and therefore a special needs trust may be needed to protect these benefits. And within this category, the two main programs are really supplemental security income, SSI, and Medi-Cal, which is essentially Medicaid in California. There are additional programs under needs-based benefits that we won't really get into today, but those include in-home supportive services, CalFresh, and Section 8 housing. So let's go to the next slide. All right, so the Social Security Administration has a specific definition of having a disability for purposes of determining their eligibility for programs such as SSI and SSDI, and it's essentially, they define it as the inability to engage in substantial gainful activity due to a mental or physical impairment that has lasted or expected to last 12 months or result in death. In other words, a mental or physical condition that prevents you from earning a certain amount of income per month, which in 2023 is $1,470 for an individual. So let's go to the next slide. So when you work, you pay taxes. Some of those taxes goes into the federal government's Social Security Trust Fund. And if you paid into the Social Security taxes for a long enough time, you have to stop working because of a disability, the federal government will pay you monthly cash benefits known as Social Security disability insurance. To qualify for SSDI, you have to meet the Social Security Administration's definition of having a disability and have worked and paid into the system for a sufficient period of time. An adult child who is unmarried and has a disability that began before the age of 22 can qualify for SSDI benefits based on a parent's earning record if the parent is disabled, retired, or deceased. This is known as childhood disability benefits, which pays 50% of the parent's Social Security benefits when the parent is retired and 75% of the parent's Social Security benefits when the parent is deceased. As an entitlement benefit, there are no resource limits for SSDI, but the Social Security Administration does consider SSDI as a type of unearned income that reduces SSI benefits, for which I'll address a little bit more in a moment. So let's go to the next slide. So Medicare is health insurance for those who are 65 and older, or for those who are younger than 65 and have received SSDI for at least 2 years. Medicare is essentially a collection of related programs called parts, named by letters, and each program just helps pay for a different aspect of your medical care. Let's move on to the next slide. Supplemental Security Income, or SSI. It's a federal program that provides monthly cash benefits for food and shelter to people who are 65 or older, blind or disabled, and who have low income and few resources. You do not need to have worked in the past to receive SSI. The maximum amount that the federal government pays is called the federal benefit rate, which currently is $914 per month for an individual. Some states, such as California, will supplement the federal amount. In 2023, an individual in California can receive a maximum of approximately $1,133 per month in SSI benefits. Let's move on to the next slide. To qualify for SSI, you must first meet the Social Security Administration's definition of having a disability, which is essentially, again, that inability to earn $1,470 per month due to your physical or mental impairment. Second, you cannot have more than $2,000 in accountable resources, which includes cash or other property that can be converted to cash and used for support. Though some assets are exempt and not counted, most notably a primary residence of any value, one vehicle of any value, as well as items of personal effects and assets in special needs trust and ABLE Act accounts. It's also important to note that if you transfer resources for less than fair market value during what they call the look-back period, you will be penalized and become ineligible for SSI for up to 36 months. The look-back period is also 36 months and runs from the date of the application of the SSI benefits or the transfer of the assets, whichever is later. To calculate the period of ineligibility, you take the amount transferred divided by the monthly SSI benefits being received. Additionally, SSI has income limitations, and the type of income and extent of income determines how much SSI benefits the recipient will ultimately receive. So let's go to the next slide. Earned income includes salaries, wages, tips, self-employment income, and royalties. After the first $65, earned income reduces the amount of SSI benefits $1 for every $2 earned. Social Security Administration also provides a general $20 exclusion of any type of income. So to give you an example, if the SSI recipient earns, say, $205 in a month, you reduce it by $20 by the general exclusion, take away the first $65, that brings you down to $120. The SSI benefits would be reduced by $60. All right, let's move on to the next slide. So unearned income is essentially all income that is not considered earned income, which includes inheritance, gifts, annuities, pensions, alimony payments, dividends, gambling winnings and prizes, veterans benefits, unemployment benefits, and even SSDI benefits. The effect of unearned income is much greater than that of earned income. Unearned income reduces SSI benefits dollar for dollar after that $20 general exclusion. Let's move on to the next slide. So the Social Security Administration recognizes another type of income called in-kind support and maintenance, which essentially consists of food or shelter provided directly to the SSI recipient or paid by a third party. The Social Security Administration defines shelter broadly to include rent, mortgage payments, property taxes, and utilities such as heating fuel, gas, electric, water, sewage, and even garbage removal. There are two different rules for determining the amount of SSI reduction based on the individual's living arrangements. But generally speaking, in-kind and support and maintenance will reduce SSI benefits up to 1/3 of the federal benefit rate, so roughly $300. To apply this in the context of a special needs trust, this means that distributions from the special needs trust to pay for our beneficiaries' room and board, for example, will be considered in-kind support and maintenance and reduce the SSI benefits by up to 1/3 of the federal benefits rate. Therefore, a trustee making distributions for our SSI recipient must be familiar with Social Security, Supplemental Security Income's eligibility requirements and the rules for counting income and resources. Let's go to the next slide. So Medicare is our national health program for people with low income. This includes people who are elderly, disabled, or have high medical costs. Medicaid will help cover doctor visits, hospital stays, prescription drugs, rehabilitation, and other medical services. Each state runs its own Medicaid program, and in California, it's known as Medi-Cal. There are numerous ways to be eligible for Medi-Cal, but perhaps three of the more common Medi-Cal recipients include those who are categorically linked, meaning those who receive SSI benefits, even as low as $1 are automatically eligible for Medi-Cal. There is what we call Magi Medi-Cal or income-based Medi-Cal, which provides full scope services to, again, those who are elderly, blind, or disabled, and who have low income at or below 138% of the federal poverty limit. There is no resource limitation for this Medi-Cal program. And then there's the aged, blind, and disabled Medi-Cal, also referred to as medically needy or share of cost Medi-Cal. And this is if your income is too high to qualify for other Medi-Cal programs, you can qualify with what we call a share of cost, where you essentially have to spend a certain amount of your own money before Medi-Cal begins paying for medical services. So essentially functions as a monthly copayment. Many of the Medi-Cal programs do have a resource limitation, which has historically been $2,000, just like SSI. But as of last summer, that limit was increased to $130,000. And in 2024, the resource limit will be eliminated entirely. Let's go on to the next slide. All right, so special needs trusts essentially fall into, sure. usually, special needs. So if I understand your question, you're asking if the term disability or being disabled is equivalent to the word special needs. So at least in this context, the term that I'm discussing about being disabled is specifically for, purposes of determining eligibility for Social Security programs. Typically, special needs is synonymous with supplemental needs. It's supposed to, supplement the needs of what public benefits are providing for. So I guess in certain contexts, it might be synonymous, but perhaps in others not, if I'm understanding your question correctly.
So, I mean, yes, it includes disabled, but it includes people who are mentally ill. It can include people who are elderly, over 65. So when we use the term disabled, it's pretty broad. Does that answer your question?
And then someone has to be disabled to establish a special needs trust as well. So I think the definition of disability is connected to the Social Security rules about whether or not somebody meets that threshold of being disabled, so they can establish a special needs trust. But because you have special needs doesn't necessarily mean you're diagnosed with a disability under the eyes of Social Security and Medi-Cal. So, the example that comes to mind that we often discuss is, Stephen Hawking had special needs, but he wasn't disabled because he was able to work. He was able to gain and earn more than the monthly income for Social Security purposes. So he wasn't considered disabled under the eyes of the government, as an example, but he did have special needs. So I think the terms you have to be careful in kind of using them interchangeably, because they have different connections and meanings. And in particular, when it comes to special needs trust, you kind of have to be careful as to how you're defining somebody, whether it's, special needs situation. Yes, somebody can have a disability, but they're not able to receive government benefits because they can work. So individuals with high functioning autism is an example where they can work. Maybe they don't meet the threshold of being disabled for Social Security purposes, but they can still have special needs where a third or first party trust can still be beneficial to that individual. Does that kind of clarify? Okay.
Thank you.
Didn't need to interject.
No. All right, so let's go on to okay, no, we're on slide 14. Okay, yes. All right, so special needs trusts fall into two basic categories: first party and third party special needs trust. And the main factor that determines which type is needed essentially is the source of assets that is to fund the trust. So a first party special needs trust can only be funded with assets that belong to the beneficiary with a disability, while a third party special needs trust, as the name implies, can only be funded with assets that belong to someone other than the beneficiary with a disability. So we're going to go on to the next slide, and I'll let AJ now talk to us about first party special needs trusts.
All right, thank you, Bronson. So I have the task of going through first party special needs trusts in about 10 to 15 minutes. So I'm gonna power through these slides. But my plan is to outline the key elements of a first party trust, provide some examples on when a first party trust would get funded and the type of assets that would go into a first party trust, and then point out a few mistakes that I've seen when it comes to creating and administering a first party trust, and some common issues that I've come across with practitioners putting these trusts together. Next slide, please. So a first party trust goes by a variety of different names, as you can see on the top of the slide. Goes by self-settled, litigation S&T, D4A, OBRA 93. So there's a variety of different names that a first party trust goes by, but it all refers to the same standalone first party special needs trust. This type of trust can be established by parent, grandparent, legal guardian, the court, or the beneficiary. As of somewhat recently, can now create his or her own first party special needs trust, which is huge and significant because we don't need somebody to create a trust for somebody over the age of 18 who's competent. That person can now create their own first party trust, and we're not going to court to get that done, or we're not having a parent or grandparent get that done for that individual. That person can create their own first party trust. To create a first party trust, the beneficiary must be under the age of 65. If they're over the age of 65, we have another option, which is joining a pooled special needs trust, and Carol's going to discuss pooled trusts later on in the presentation. But there is an option for that individual if they're over the age of 65 and they need to create a trust to have those assets transferred into. If somebody has a first party trust in place and they're under the age of 65, they subsequently receive funds when they're over the age of 65, they can't put those additional funds into the trust that they have in place already. They're going to have to likely join a pooled trust to add those additional funds into. There's no augmentation or adding additional lump sum payments into an already established first party trust. They're going to have to create something new for those additional funds to go into. The major exception to that are annuity payments. So we often get involved with settlement planning with PI attorneys, plaintiffs counsel, and part of that planning includes structuring some of those settlement proceeds, and those annuity payments can pay into the first party trust even when the beneficiary is over the age of 65, and that's not going to be considered augmenting or adding additional funds to that first party trust. The beneficiary has to be diagnosed with a disability. So somebody who's receiving public benefits, that's pretty self-evident that that person's receiving or is disabled because they're receiving SSI, for example, and that's based off of income, as well as being diagnosed with a disability under the eyes of the Social Security Administration. I bring that up only because I've had a situation once where a young lady was receiving Medi-Cal, and we had a discussion about what to do with the settlement proceeds that she was getting, about $50,000. And it turns out that she was on income-based Medi-Cal program. She didn't actually have a disability, so she couldn't legally set up a first-party trust. She was able to receive those funds, and it wasn't going to impact her income-based only Medi-Cal benefits. The beneficiary can't have any type of control over the funds in a first-party trust. The trustee has sole and absolute discretion over the distributions of the funds. The beneficiary can't compel the trustee to make a distribution. The beneficiary can't remove and replace the trustee. The beneficiary really has no control over the trust assets, and that's necessary to make it a valid first-party special needs trust. But the flip side to that is the trustee can only use the funds for the benefit of the beneficiary. This is really kind of a sole benefit trust where the beneficiary is the primary beneficiary or the sole beneficiary of this first party trust. And the trustee can't use the funds to make distributions to the beneficiary's friends. The trustee can't gift the funds away. The funds really can only be used for the benefit of the beneficiary. There's a few exceptions to that rule, and Social Security has kind of outlined a few examples when that's an appropriate distribution to pay for caregiving services for somebody who's traveling with the beneficiary, somebody to go visit the beneficiary to make sure they're doing okay. The trustee could pay for them to travel. There's also this kind of third-party derivative benefit rule where the trustee, I like to say it's like the TV example, the trustee buys a TV for the beneficiary. That doesn't mean that somebody can't go and watch a movie with the beneficiary using that TV. So there is some leniency there, but it overall has a pretty strict standard in terms of only using the funds for the benefit of that beneficiary and nobody else. Otherwise, the trustee's looking into some issues with Medi-Cal when the trust terminates. So it's an important rule to be aware of when you're serving as a trustee of this type of trust. Next slide, please. If the beneficiary doesn't have capacity or is a minor, then we're looking at going to probate court to establish the first party trust. And that's either done with a 3604 petition or a 2580 petition, depending on the source of funds, whether or not the beneficiary is conserved. And so that's a court-involved process where we get the court to approve the establishment of the first-party trust. Then we're subject to doing annual or biannual accountings and having that trust remain under the court's jurisdiction. Change in the rules, and we need to make sure that the SNT, the Special Needs Trust, remains a valid trust. So we need to have the trustee have the ability to amend the trust if there's a change in rules. And actually, that was pretty relevant a few years ago when the Medi-Cal payback language was changed under Social Security, and we had to update the language in our trust to reflect that change so that the trust remained a valid SNT and everything in the trust remained exempt for SSI and Medi-Cal purposes. So it is necessary to have the trustee have the ability to amend the trust, and it's primarily for modifying the trust so it's up to date with current law for Social Security and for Medi-Cal. I think one of the most important aspects of a first-party trust is that it has a mandatory Medi-Cal payback provision in it. This states that when the trust terminates, whether it's during the beneficiary's lifetime or on the death of the beneficiary, the Medi-Cal is entitled to get paid back for all the services they provided the beneficiary during his or her lifetime. So this is a lifetime Medi-Cal lien on trust assets. It's not from when the trust is created. It's from however long the beneficiary was receiving Medi-Cal services. When the beneficiary passes away, for example, we notify Medi-Cal, they send a bill. Sometimes there's a little bit of room to negotiate, but often it's just paying the bill. Medi-Cal is entitled to collect whatever's in the trust. They can't exceed the trust assets. So if the Medi-Cal lien exceeds what's the current balance of the trust, Medi-Cal only collects what's in the trust and nothing else. They can't go after the trustee for the additional funds or anything like that. They are limited to whatever's in the trust. So quite often, if somebody's receiving Medi-Cal for a period of time, that lien does exceed the amount that's in the trust. So we just pay back Medi-Cal, close out the trust, and then it's taken care of. If the lien is less, sometimes that does happen. Typically what happens then is once we pay off Medi-Cal, the balance is then distributed to the beneficiary's heirs at law, or if they exercise the power of appointment, then we can have those funds pay out to those beneficiaries under that will or trust. So that's, I think, a very important concept to keep in mind, in particular that it's a lifetime lien, not from when the trust is created. I think sometimes that can be a misunderstanding about how that Medi-Cal lien works. It has very specific language in it, and I think Social Security and Medi-Cal, when they review these trusts, one of the first provisions they look at is that Medi-Cal payback provision to make sure that it's valid, current, and up to date. If it isn't, then they will deem the entire trust as invalid, and then you're going through the appeals process and going down that road, which is something that you want to avoid, and you don't want the beneficiary having to stress about losing or potentially losing SSI and Medi-Cal because they often rely on that as their only source of income. Next slide, please. So this slide provides several examples on the types of funds that will pay into a first-party trust, including personal injury and medical malpractice settlements. We typically like to get involved early on in that process to help the transition from litigation into SNT administration. That includes working with the family to create a budget, selecting a private professional fiduciary as a trustee, those things. So it's a simpler process when it comes time to actually administer the trust instead of, surprise family. Now we need to do something with the funds after they've been through years of litigation. So if we can get involved earlier, it makes the process easier for everybody when it comes time to get this trust established and created. And if we need to go to court to get our petition approved, then we need to get that done first and then provide a copy of the court order to the plaintiff's attorney so they can include that in their compromise petition to get that taken care of in civil court. A beneficiary is named directly in a will, trust, or receives a lifetime gift. Then we're looking at creating a first-party trust depending on the amount of assets, retroactive SSDI payments. I think that's probably a little bit less of a concern because if somebody's only getting SSDI and not SSI and Medi-Cal is the only concern, then they can probably keep those benefits and not lose their Medi-Cal because of that new resource limitation that Medi-Cal has implemented. And then if the beneficiary is named directly on life insurance proceeds, it's named as a beneficiary on retirement accounts or a custodial account. These are all examples where the beneficiary has, a vested interest in assets, then that will require a first party trust. So these are all situations that we come across that require somebody to set up a first party trust. It doesn't require that the beneficiary have check in hand. These are just examples that demonstrate the legal construct of somebody having ownership interest in assets that will then require them to set up a first party trust if that's the appropriate thing to do. Next slide. Yeah. Yes, is a house excluded from, resource issues for SSI and Medi-Cal? So the beneficiary can own a primary residence of any value, and that's not going to impact their SSI and Medi-Cal. Sure.
But they need to put it into a revocable living trust, or it'll be subject to payback when they pass away. The house would be subject to Medi-Cal payback if it has to go through probate. So you want to.
Right. Yes. So Medi-Cal has a recovery from first party trusts as well as a state recovery for assets that are exposed to probate. So it's exempt for SSI Medi-Cal purposes, but if somebody passes away and they own a home in their name, that home's going through probate, then Medi-Cal puts a lien on that asset and can get recovery from the proceeds of that sale. So yeah, so Medi-Cal can come after you in multiple ways. So even though it's exempt, you still need to have that, or that individual still needs to have that home in a trust. Sure. A few other examples of when a first party trust is going to be necessary include if a client or a parent is a retired teacher in California, the CalSTRS program now allows that teacher, client, parent to create a first party trust and have that pay or have that receive the CalSTRS payments when that individual passes away. Child support payments, so in situations where there's a divorce and maybe there's a minor with a developmental disability, we want to get involved and assist the family law attorney to make sure that an S&T is created and established and referenced in the MSA, and have those future child support payments irrevocably assigned into a first party trust, so that those payments won't count as income for that individual. Lastly, this issue comes up from time to time, but when we have clients who are in the military or who have served in the military and no longer on active duty, for example, they can sign up for a retirement program called the Federal Survivor Benefit Plan, and they can now have those payments when that individual, that member passes away. Those payments can now be assigned to a first party special needs trust. There's a few other documentation or a few other documents that have to be in place, including attorney certification, a statement by the member that they want to irrevocably assign that election to that child to now pay into a first party trust. And then all that gets reported to the Defense and Finance Accounting Services out in Indianapolis, I believe. And then that election then is irrevocably assigned and updated to reflect those payments when that member passes away to pay into that first party trust instead of paying directly to that beneficiary when you go into income issues and that sort of thing. So with that, can we go to the next slide, please? So we're going to discuss third-party trusts, and I'm not sure if Bronson's going to get into some of those issues, but under Secure and Secure 2, I think it's still beneficial to name a third-party supplemental needs trust as a see-through accumulation trust to receive retirement benefits. So that would be my understanding, and I'm not sure if we have time to get into those specific nuances. but a third-party supplemental needs trust as an accumulation see-through trust, to me, still makes sense as a beneficiary on retirement accounts. So some common mistakes I've seen with first-party trusts for administration purposes. This is a grantor trust regardless of who establishes the trust. And I've seen on multiple occasions CPAs treat this as a complex non-grantor trust, which is incorrect. So when we are filing returns for first-party trusts, we still want to treat this as a grantor trust and have all income deductions and credits passed down to the beneficiary, which is more advantageous than having the trust pay taxes at the trust tax rate. I've also seen a first-party trust named as a beneficiary in somebody's estate plan, whether that's a revocable living trust or as a beneficiary on retirement accounts and IRAs. We want to avoid that. That's unnecessarily assigning third-party assets to a first-party trust. And again, now that's exposing family assets to a Medi-Cal lien, which we want to avoid. And Bronson's going to get into third-party trusts in just a moment. But that's really unnecessary. And I've had a couple situations with clients where the previous estate planning attorney said, it's a special needs trust. What's the difference? It doesn't matter. It's fine. And I tell them the issues with that, and they're partly irritated, but partly relieved that I'm going to fix that for them. But in one situation, the family left everything to their daughter's first party trust, not knowing that they just potentially attached millions of dollars to a Medi-Cal lien, which was likely going to be pretty significant. So fortunately, we were able to fix that, and we didn't have to deal with issues of trying to unwind that, which I don't think you could probably do, and go into litigation with Medi-Cal, something that we want to avoid. And then a few other issues I've seen with drafting errors in SNTs. These are pretty technical documents, and you really need to have a mastery knowledge of the Social Security regulations and the Medi-Cal regulations to make sure every word, every sentence, every paragraph is compliant with their rules and regulations. And sometimes things change. I've seen incorrect Medi-Cal payback provisions, early termination provisions that don't necessarily state the rules correctly. I've seen first-party trusts that give the trust or give the beneficiary control over trust assets, and that's an issue. So these are just some of the drafting issues I've seen with these types of trusts and things that we want to avoid moving forward. With that, I'm going to turn things over to Bronson, and he's going to discuss third-party trusts.
Thank you, AJ. We move to the next slide, please. All right, so kind of running out of time, so I'm going to try to go to this fairly quickly, as I know you all want to hear from Carol as well. So let's go to the next slide. Okay, so third-party special needs trust. Third-party special needs trust is commonly created by parents or grandparents in conjunction with their own trust and estate plan. There are some notable differences when contrasted with a first-party special needs trust. One, third-party special needs trusts do not require court supervision, regardless of the beneficiary's capacity or whether or not they're a minor. There is no sole benefit requirement like there is with a first-party special needs trust. And with third-party special needs trust, obviously the trust can be funded with gifts from third parties. Again, assets that belong to someone other than the beneficiary. And because the assets in the third-party special needs trust do not belong to the beneficiary, the trust assets are protected from the beneficiary's creditors and other third parties, including Medi-Cal. There is no Medi-Cal reimbursement requirement with third-party special needs trusts like there are with first-party special needs trusts. Let's go on to the next slide. All right, so since third-party special needs trusts are funded with assets that belong to someone other than the beneficiary, they're typically funded with an inheritance from the beneficiary's parents or other family members, life insurance death benefits, again, typically held on the life of a parent or grandparent, and lifetime gifts made by family members or friends directly to the special needs trust. Let's go to the next slide. So in our firm, we always prepare our third-party special needs trust as a standalone document rather than as a testamentary subtrust. There's numerous advantages for doing it this way. For one, you can maintain a greater level of privacy for the settlors, particularly as it pertains to their own revocable living trust. Anyone entitled to see the third-party special needs trust document such as government agencies when reporting the funding of the trust won't see the settlor's revocable living trust. The beneficiary is later determined to be able to handle his or her own financial affairs. The special needs trust can be terminated without affecting another trust. And as a standalone document, the special needs trust can have different terms and different trustees from what the parents' trust provides. Overall, it just makes things easier to administer, particularly as it pertains to, titling assets in the name of the third-party special needs trust, or to designate, the third-party special needs trust as beneficiary of life insurance policies, retirement plans, and other assets or accounts of beneficiary designations. The beneficiary's parents get divorced, they can still direct gifts to the third-party special needs trust from their own respective estate plans. And the special needs trust won't be affected if the parents' own revocable living trust is terminated. Let's move to the next slide. So administering special needs trusts is complex. So the trustee is oftentimes a corporate trustee or a private professional fiduciary. And in such situations, the special needs trust should really give someone other than the beneficiary oversight over the administration, particularly the power to remove and replace trustees. And this is generally handled by a trust protector or trust advisory committee. The role of a trust protector or advisory committee is defined by the terms of the special needs trust, but the usual role is to provide guidance to the trustee regarding the beneficiary's needs, to help resolve disagreements or dissatisfaction with the trustee, and when needed, to remove or replace a poorly performing trustee. The trust protector is typically someone who is acquainted with the settlor's family and understands the needs of the beneficiary. The trust protector is typically authorized to review accountings and to oversee how the trust assets are being invested. Additionally, they usually are able to modify the trust to keep it current with changes in laws or changes in the beneficiary's circumstances, or to correct errors or ambiguities in the trust, and really just overall to ensure that the trust is being administered as the settlor is intended. A trust advisory committee is just essentially more than one trust protector acting together, and typically includes family members or friends of the beneficiary, and sometimes even professionals. So family members and friends can assist the trustee in understanding the day-to-day needs of the beneficiary, and sometimes just provide a voice for the beneficiary. Professional members of an advisory committee may include clinical social workers who can provide care management for the beneficiary, consultants such as an attorney who is familiar with Social Security and Medi-Cal regulations to ensure that distributions don't violate income or resource rules, or even financial professionals who can design an investment strategy for investing the trust assets. Let's move on to the next slide. So a letter of intent essentially is an informal letter to the trustee prepared by the settlors, again, typically the parents, which can include just about anything, but the general purpose is to provide useful information to the trustee and future caregivers, such as what makes the beneficiary happy, what makes them sad, what foods the beneficiary like, dislike, what are the beneficiary's hobbies. The beneficiary might be involved in day programs or sports programs. Maybe they have a caregiver that accompanies them to extracurricular activities. It's good to include information about the beneficiary's doctors, medications, any allergies they may have. Parents sometimes include what their hopes and plans are for their child's housing in the future. Maybe they would do well in a group home, or perhaps benefit more by being in their own apartment or by staying in the family residence. The letter of intent should include services and public benefits that the beneficiary receives or is anticipated to receive. Are they receiving SSI, SSDI, Medi-Cal, Medicare? To be most effective, the letter of intent should really be continually updated over time. All right, so let's go to the next slide. So I'll just wrap up with mentioning a few common mistakes regarding third-party special needs trust. Really, the first of which is simply not knowing about third-party special needs trusts, particularly when a parent believes that they have to disinherit their child in order to preserve their public benefits. But disinheritance, leaves the child with, at the mercy of government policy, with no guarantee that the government will continue to provide public benefits for the disinherited child. And it provides no plan for continued advocacy or care for the child. Another common mistake is, funding a third-party special needs trust with the beneficiary's own assets. In regard to drafting errors, third-party special needs trust should not include Medi-Cal payback language. And as AJ discussed, the special needs trust should not allow the beneficiary to demand or direct distributions from the trustee or to have the power to amend or revoke the special needs trust. A third-party special needs trust does not need to be irrevocable to preserve public benefits. As long as the trust is revocable or is not revocable by the public benefits recipient, trust assets will not be countable resources for SSI and Medi-Cal eligibility purposes. A revocable third-party special needs trust gives the settlor the flexibility to modify the trust if there's changes in laws or the beneficiary's circumstances change. Also, having certain termination provisions is also prudent. Generally, the third-party special needs trust will terminate upon the death of the beneficiary, but the third-party special needs trust may also terminate, if the beneficiary is no longer eligible or no longer dependent on public benefits due to sustained employment, or perhaps if the special needs trust corpus is so small that it's not economical to continue to administer the trust. And perhaps one of the more common mistakes that we see with third-party special needs trust is an overly restrictive distribution standard, which would essentially be language in the trust that says that under no circumstances can a trustee make distributions for things that would otherwise be covered for by public benefits. A fully discretionary distribution standard is really desirable in most circumstances, which would allow the trustee to have sole discretion to make distributions for things that may otherwise be covered for by public benefits if the trustee concludes that any loss of benefits is outweighed by the increased quality of life for the beneficiary. And a common example of this would be to purchase or maintain a residence for the beneficiary, and if the beneficiary is receiving SSI, such distributions would be counted as in-kind support and maintenance and reduce the SSI benefits, but might still make sense to provide for a better quality of life. All right, so with that, if we go to the next slide, I'm gonna let AJ talk to us about ABLE Act accounts.
All right, thank you, Bronson. So I know we're crunched for time, so I'm going to kind of power through these slides pretty quickly so we can get to Carol's portion of the presentation. So an ABLE Act account was the federal government's way to address this $2,000 resource limitation for SSI and Medi-Cal recipients, really now SSI recipients because the Medi-Cal rules have changed. So instead of increasing the $2,000 threshold, they came up with this kind of nifty savings / investment account for recipients of SSI and Medi-Cal so they can have more than $2,000 in their name and keep their SSI and Medi-Cal benefits. So when you set up an ABLE Act account or when somebody establishes an ABLE Act account, that beneficiary is the owner of the funds, unlike a SNT where the trustee is in control of the assets. An ABLE Act account, the beneficiary actually owns those assets. It's a tax advantage savings account modeled after the 529 college plan. So funds in the account grow tax free, although I think the average account throughout the country is like $10,000. So it was designed to be a savings account, but it's really turned into kind of a money in, money out account where funds go into the account and then funds subsequently come out of the account to pay for expenses for the beneficiary's benefit. So even if someone is eligible to establish and have an ABLE Act account, I think a couple of important considerations include, does the beneficiary have spendthrift issues, or is there money management issues? Does it make sense to have the beneficiary in control of $5,000 or $10,000, or not? Another issue is undue influence issues. So I worked with families and clients where, yeah, the individual could have a ABLE Act account, but there was concern of undue influence, somebody taking advantage of the beneficiary. If somebody just figured out this individual had a whole bunch of money in the ABLE Act account, there's concern that that money would disappear and that individual would be taken advantage of. So I think there's some practical considerations when it comes to having an ABLE Act account in place. Next slide. Is it eligibility requirements? That one? Oh, sorry, I just went through that one. Next slide. So it should be eligibility requirements. Perfect. So to be eligible for an ABLE Act account, the individual must have been diagnosed with a disability before the age of 26 and eligible or is receiving SSI or SSDI. If that isn't satisfied, then a doctor can self-certify that this individual is certified that the individual is diagnosed with a disability before the age of 26, and that disability meets the definition that Social Security has in their regulations. And as of 2026, the age of onset of disability is going to increase to 46, which I think will be beneficial for a whole group of individuals who might receive small amounts of money, and they have a place now where they can put those funds. They don't have to spend it down or come up with a plan to have those funds transferred to a trust, for example. So I think it's going to do a lot of good for an additional group of the population. Next slide. So anybody can establish an ABLE Act account, including the individual, the parent, legal guardian of the individual, agent under a power of attorney, and recently the representative payee. So if nobody on that list is able to create an account for the beneficiary or the individual, the representative payee, who's the person in charge of the Social Security payments for the individual, can establish an ABLE Act account. Anyone can fund it. So this is kind of a savings account where assets can be commingled from first-party assets and third-party assets. So the beneficiary can put funds into that ABLE Act account, as well as family members, friends. Anybody can make a contribution. It's not a deduction, but it's a contribution for somebody's benefit. Next slide. If this is something that a family is looking at doing, I recommend setting an ABLE Act account or establishing an account in California. California isn't seeking recovery when the beneficiary passes away. So federal law authorizes the states to have Medi-Cal or Medicaid get paid back when somebody passes away and they have an account established. California is not exercising that payback. So like that first party trust, there's Medi-Cal payback provision and language. If somebody passes away with a Cal-Able account, Medi-Cal is not seeking recovery, and the funds will just pay to the beneficiaries' heirs at law, beneficiaries' estate, and those funds will be distributed accordingly. If you have an account, or if a family has an account for a child, for example, in a different state, I just tell them to transfer it to California, which is permissible, and then they have that Cal-Able account, and then there's no longer a lien attached to those assets, and they can continue on with the Cal-Able program. The beneficiary can manage the funds if that individual is competent. If that person isn't, then the person with signing authority over the account, typically the parent, will manage the funds for that individual. And for public benefits purposes, the individual, whether they are competent or not, is the owner of the account, and they can have one account total. It's not one account per state, it's one account, and that's it. Next slide. A couple of limitations when it comes to the ABLE Act account. So there only can be up to $17,000 in terms of contributions each year. That's based off of the annual gift tax exclusion amount. So that goes up every year. If somebody's working, they can contribute to the ABLE or part of the ABLE to Work Act program. They can add an additional $13,600 or so into their ABLE Act or ABLE account program for an additional $30,000 or a total of $30,000 and change. But keep in mind, if you're working, that's earned income, and that's going to impact your benefits depending on how much you're bringing in. There's a maximum of $100,000 in the ABLE account that's exempt. If you go over that amount, then that person's going to lose their SSI benefits, or their SSI will get suspended. They'll keep their categorically linked to Medi-Cal benefits. Once they spend things down and they're below the $100,000 resource limitation, the SSI gets reinstated, and things will continue on as they were. Medi-Cal is not taking an interest, and so the balance of the ABLE account is not going to be a problem for Medi-Cal purposes. They don't really care about how much is in that account. So Medi-Cal eligibility is not going to really be impacted by balance of an ABLE Act account. And funds in the account are used for what are called qualified disability expenses. That's anything related to the beneficiary's disability that enhances and benefits their quality of life. I think the important note to take from a QDE is that a QDE includes food and shelter expenses. So a beneficiary can use funds in an ABLE Act account to pay for food and shelter, and that's not going to be considered income, and that's not going to reduce their SSI. Next slide. So tying this all together pretty quickly, if there's a funded first or third party trust, the individual qualifies for an ABLE Act account. What can happen, and what we sometimes recommend, is having the trustee transfer funds from an SNT to an ABLE Act account. The funds in the ABLE Act account can then be taken out and used for food and shelter expenses, and that's not going to reduce the SSI. It's not going to count as income, so the SSI is going to be maintained, and then they can have the benefit of the ABLE account paying for food and shelter and continue on. So with that, I'm going to turn things over to Carol, and she's going to go into pooled trusts.
So ABLE Act accounts are a workaround.
They're a workaround.
Okay, so I'm really happy that I get to talk about pooled special needs trusts because I think this is an area that is really underutilized by estate planning attorneys and financial planners. Pooled special needs trusts aren't really a different kind of trust because there are first-party pooled trusts and third-party pooled trusts. They all have to be run by a nonprofit organization, and that nonprofit is the trustee of that pooled trust. There is a master trust if, depending on first or third. So there's a first party master trust, a third party master trust. And it can be a lot more cost effective for families that might not be able to otherwise afford setting up a special needs trust. We always preach the importance of doing a standalone third-party special needs trust. But some attorneys tell me that the way they have their business, it doesn't fit into their pricing schedule, or it's too much time. They don't want to do the standalone. They have their standard format where it's a subtrust. Subtrust special needs trusts are really difficult to administer because you don't know, do all the same provisions apply to that special needs trust, for one thing, and do you want the same trustee to be the trustee of the revocable living trust or the successor trustee, and also the trustee for the special needs trust? If you want to have a sort of standalone without having to draft one or change your practices, you can use a pooled special needs trust as a third party because it is a separate document. There would be a separate knowledgeable trustee about how to run that trust. It's going to provide ongoing stability because it's a nonprofit that will go on and on for many years. And it's going to be less of a burden to the family to, nobody in the family is going to have to keep the records, deal with a difficult beneficiary. In San Diego, so there are pooled trusts all over California, all over the US, and we've worked with quite a few of them. We've done a cost analysis of administration costs and investment costs, and our local pooled special needs trust is one of the least expensive. It's called the Special Needs Trust Foundation of San Diego. And if you use that, it's the only pooled trust you'll use where a beneficiary and the family will actually have a face-to-face meeting with the family and the beneficiary. All the other pooled trusts are not administered here, so meetings are going to be maybe Zoom or any requests or issues would be dealt with by email and telephone. The local Special Needs Trust Foundation is an organization that was formed by about 10 different nonprofit organizations, such as the Home of Guiding Hands, St. Sophie's Center, the NAMI, the National Association for the Mentally Ill, Noah Homes. So each of those organizations has a seat on the board, and there's an executive board. The executive director that runs the day-to-day operations is a professional fiduciary. And then there's also a professional fiduciary on staff that advises the executive director and meets with the families. So if you use this as a third party, you would want your clients to fill out the joinder agreement ahead of time so that the trust is set up. It costs $100 to set up a trust with a third-party trust. Then that third party can be named as beneficiary for life insurance because it's a valid trust. It's funded. It can be named as a beneficiary for life insurance, pension plans, and by other family members in their documents. I'm not going to switch slides because you can read it. I just thought I could go through it faster. The first parties can be set up very quickly. If you have a client who is on public benefits and they get an inheritance and they need this done quickly and they're competent, but don't really have anybody in the family to be a trustee, then they can get a trust set up with a foundation in about a week. A lot of times the pooled trusts for the first party do want a beneficiary to be represented by an attorney because that's an irrevocable trust. And the pooled trust wants to be sure that the beneficiary has been fully advised of their other alternatives before setting up the first party. But it can be done pretty quickly. For fees for the Special Needs Trust Foundation, if a family establishes a third party with $100, then it's sitting there waiting until it's more fully funded from the family trust or the family estate. Once it is funded, they don't charge fees for the lifetime of that trust. So if that trust is spent down to zero, all the foundation ever gets out of it is $100. If the beneficiary passes away and there are still funds in that trust, half can be distributed to designated beneficiaries by the parents or whoever the settlors are that established that trust. The other half stays with the foundation, with 25% goes to the foundation for operating costs and 25% to one of the member organizations. So the third party Special Needs Trust is really kind of the charitable arm of the first party. The first party, they do charge, it's $1,000 to join. It's about 1% of the funds that they have in management, unless it's 150,000 or less, and then it's $100 a month, which is pretty reasonable for these smaller trusts until it gets down below 5,000, and then they do a spend down plan and they don't charge anymore. So I think it can be a good problem solver for situations where maybe you can't afford to do a standalone third party. You don't want to bring in a separate firm like ours to do the third party. You can use the Special Needs Trust Foundation and it only costs your clients $100. So you can look at the rest of the slides for pooled trusts. They're administered pretty much like regular special needs trusts, except that the funds are pooled for investment purposes. Separate accounts are still maintained, so it doesn't, there's some trusts that are going to be much larger than others. I'm going to skip to fiduciary duties because I think this is really important to get in as well. You know that choosing a successor trustee for a trust is one of the most important decisions that your clients make, is who's going to run this trust once both of us are gone. Well, choosing the trustee for a special needs trust is even more important because that revocable living trust is going to end at some point, but the special needs trust will go on and on and on. And the beneficiary is usually somebody who is very vulnerable and not really able to advocate for themselves. So naming a family member, a brother, sister, whatever, is often not the best choice. They don't really understand fiduciary duty. They don't want to take the time to learn the public benefits. And they just think, I know what's best for this person and I'll take care of it. So they don't really adhere to the fiduciary duties, even though they're, as a layperson, they have the same fiduciary duty as a professional. I've never regretted naming a professional fiduciary, a trust company, or a pooled trust as a beneficiary for a special needs trust, but I have regretted naming a family member. It is really incredible what one family member will do to another one. I had a father who, the daughter insisted he could be the trustee. He took her first party money and he gambled it away. And there were no deep pockets to get it back. A brother who was resentful for this disabled brother who would hardly give him any money a month and just said that's the way the special needs trust is written. That's not true at all. So, so family members aren't always bad choices, but before you name somebody, you might let them, so the last slide says, fiduciary duties, you have to provide an accounting to the beneficiary and to the legal guardian and perhaps the court if it's a first party. You have to report to public agencies. You have to know when to report. You report the establishment of these trusts once they're funded. Then if there's changes in circumstances, there also needs to be a report. And you have to file other required income tax reports. So you need to ask a family member, are you willing to do this? Are you willing to keep the records? Because a fiduciary for a special needs trust has to keep perfect records. Medi-Cal, Social Security can ask for those accountings anytime, and you have to be able to get that to them in a reasonable amount of time. If you're doing annual accountings, of course, you've got that information readily available, but family members tend to skip that step. They also tend to skip, consulting attorneys and filing tax returns. So, so just make sure that who you're naming is really up for the job, that they don't have any money problems of their own, and that they will educate themselves on what it means to be a fiduciary. So I want to thank everybody for coming and ask if you have any questions. Yes. Yeah, we give them to disability groups and all the time, like parent support groups, things like that. NAMI, yes. Sure. Yes, and yeah, because I mean, some parents think just setting up the trust, I just need a special needs trust, but of course they need to coordinate their whole estate plan with that trust. It doesn't get magically funded from from their other assets. Sure. Yeah. We'd be happy to. I guess we can.
There we go. Carol, AJ, Bronson, thank you so very much. Obviously, these are the experts. When I moved down from Seattle 11, 12 years ago, I got to know, many of the attorneys in the big firms that we all know, and they don't do special needs trusts. They just refer them right over here. So here are the experts. And obviously there's a lot behind it as far as just some words in a document. It's the whole operation and complying with all the various laws, regulations, and rules. Thanks so much for coming. Sonny Pyon with San Diego Rescue Mission and Valerie Medina with the Trust Properties USA. We thank you for your sponsorship and attendance. We'll be meeting on August 1st for our next meeting with George Alexander on solving problems with life insurance. Thanks so much for coming.